Good morning. I'm David Cotton. It's my pleasure and privilege to welcome you to our Bitter End or Better End Exploring Post conference here. I remember bringing home my first child and walking in the door and saying, "She's here, now what do I do with her?" I had no idea how to be a parent. I had to learn as I went. Now I'm a grandparent. It's so much fun. I really understand it this time. Post is here. What do we do with it? It's in our practices. It's in our daily lives. But how do we handle it? What do we do? That's what we're here to talk about, to examine, to explore today. We have an awesome keynote speaker, and I'm just excited to introduce him to you. Mark Angelo has an amazing resume and background and training, but I asked him what he really wanted me to highlight, and what he wanted me to share with you is that he is the program director of the only ACGME accredited training program for hospice and palliative medicine. They have a fellowship program, and he's part of that. We were talking bioethics. He does that. So POLST is here. What do we do with it? How do we integrate it into our medical practice? Dr. Angelo is going to share with us now. Thank you. Welcome.
Good. All right, welcome everyone. I am Mark Angelo, and I'm here today to talk to you about advanced directives. In your typical lecture, I think that, we kind of go through this and we talk overview, and this is what I'm going to do, I'm going to do it. So, I think typically we kind of get into this overview, and first I'll start out with how I plan to bore you to tears. Then I plan to bore you to tears. And then let's review how I just bored you to tears. So what I want to do is a little bit different. Today we have an agenda. I am here to show you why it's important that you expand your understanding of this new POLST legislation, how we do it and why we do it, and show you why this legislation is important to your patients and your practice. So in order to kind of give you some information about POLST and advanced directives and how these things seem to work, we do have to start with some history, so we are going to kind of build a building here. So starting in the basement and building upward, we talk about history. And like we talk about in bioethics and like we talk about in advanced care planning, we have to kind of look at what the social mores are. So there was a time that some of us may have been born where medical paternalism was really kind of the key way that medicine was delivered. I was the physician, and I would go in and say, "Mrs. Smith, it looks like things are not going well here. I'm sorry to say, it looks like you're going to die from your illness." Well, social mores changed. 60s came around, 70s came around. We started to switch from kind of saying like, "Hey, the doctor said it, so therefore it must be right," to saying things like, "Well, what about medical autonomy? Like, don't I, the patient, have the right to say what I want to have for my medical care?" So the social mores have kind of moved from me being that paternalistic, "I'll tell you what you need," more toward this autonomous type being where patients come in and say things like, "You know what, I'd like to drive my medical care," okay? We have any primary docs or primary care practitioners in the office or in the building here? So ever have somebody come to you with a URI and you are so clear that it is a virus that there is no need for an antibiotic? However, patients say, "Look, I pay for my insurance. I pay good money for that insurance. I want an antibiotic." So because they pay for their insurance, does that mean that they deserve an antibiotic? Probably no. But, we've moved from where, what the physician says is the rule to where kind of what the patient says becomes more important. From a bioethical standpoint, you can't have really one or the other. You really do need to have a synthesis of the two. We're going to talk about, kind of where we stand now. So as the social mores changed, and as we got to a point where patients wanted to have more say in their medical care, we come to the Patient Self-Determination Act. This was in 1991. Anybody familiar with the Patient Self-Determination Act? Yeah, this is something passed by Congress that now we gave patients the right. We gave them the right. Now you have a law that says that you have the right to make decisions about your medical care. So let's talk about what are those rights. What kind of rights do patients get from this? So the first thing is that the patients have the right to facilitate their own health care decisions. They can say that I want X, I want Y, and I don't want Z. Patients have the right to accept or refuse medical treatment. And patients have the right to make an advanced health care directive. Prior to this, people were making living wills, and still do make living wills, and we'll talk about what that is in a moment. But this gave you, legislative right to make an advanced directive. Under the Patient Self-Determination Act in 1991, facilities now have responsibilities as well. So the facility responsibility, number one, is they have to inquire about and document advanced healthcare directives, okay? Any nurses ever do any intake? There's always a question that says, does the patient have an advanced directive? Click yes, click no. You discussed it with them, click yes, click no. Paperwork offered or whatever your institution may have. Facilities have a responsibility to educate staff and affiliates. So that's interesting. So the affiliates, so any owned practices, any nursing homes that you do high volume work with, you are expected to have some education about advanced directives. And facilities may not discriminately admit or treat patients based on the existence or the content of an advanced healthcare directive. This one may give some of you heartburn, and let's talk about why. Anybody here work in hospice? Anybody work in inpatient hospice? Ever hear the dictum that if you go to an inpatient hospice, you can't be full code? Okay, that is discriminating against somebody based on the content of their advanced directive. It happens. I've heard, I do hospice and palliative medicine myself. Is it logical to say that you want to be full code in an inpatient hospice facility? No. Do I have a legal right to say that you can be, that you must be no code? Probably no. I've been in on a number of debates from the bioethical standpoint about this. But, just recognize that this can be a little bit of a sticking point. So there's a lot of terminology involved when we talk about advanced directives. A lot of terminology, a lot of things that we need to think about. So we're going to talk about what does an advanced directive mean? What's a medical power of attorney? And I also want to just point out real quickly, sometimes people will come in and they'll have a medical power of attorney and a non-medical power of attorney. Non-medical power of attorney allows you to state who's going to cash my check, who's going to pay my bills, who's going to take care of my car and my cat when I'm sick and unable to take care of them. It's very lovely that people have that. I have no interest in it, okay? So a non-medical power of attorney, they don't even have to bring it in. Don't muck up your electronic medical record scanning up non-medical power of attorneys. We're going to talk about what is a living will, a surrogate or proxy decision maker, and we're going to talk about the principal versus the agent. So an advanced directive is a legal document where a person specifies actions for their health care in the event of loss of mental capacity, okay? If I fall off of this stage, I therefore say Dr. Friedman is going to speak for me today, okay? So I have now said that is what I'm going to do. That is my advanced directive, and I want to be no code, Actually, I'm not quite sure on that, but I got to think about it. Might as well be like my patients, right? So a power of attorney is different. A power of attorney is that there is a principal and there is an agent, okay? The principal is saying that, I am, as an autonomous being, will give all of the decision-making rights to someone else, okay? That someone else would then be my agent. The advance directive tells you kind of what does the patient want. So they can put things in there like, in the event of terminal illness, I would not want intubation. Or no matter what, even if I'm considered brain dead, I would like to have CPR attempted. We'll talk about that in a moment. And then the power of attorney tells us who is going to convey those wishes. So this gives you the what, this gives you the who. Advance directives have to be signed and notarized, or signed by an attorney. We do have a couple of attorneys present, right? We won't talk about them. And it is the patient instruction to withhold withdrawal care in the event that the patient loses capacity. And I very specifically put this in here. Advance directives come into play when a patient loses capacity. If you have a patient who has full decision-making capacity and they're fully sentient and sitting up on the bed and talking to you, I'm sorry to say, you have to talk to them. You can't just read the paper and say, this is what their advance directive says, now I have a code status. You have to talk to your patient. So there are pros and cons of the advance directive. So we got some real good stuff out of the 1991 PSDA, but there are some problems. So the pros are that it's durable. So what does durable mean? Durable means that it is in place until it is rescinded. It can be rescinded in writing. It can be rescinded verbally. If it's rescinded verbally, please have a witness or two. Pros, it may be situation specific. You could put anything you want. If I develop a terminal condition, if I am tethered to a ventilator, I would never want to have a feeding tube. Okay, so very specific. I like to look at the advance directive as kind of a tool for communication. It is not the be-all and end-all of what we need in terms of end-of-life preparedness. It is a tool. It is a tool that mom who has metastatic lung cancer can talk to her daughter. And they can kind of come together to say, like, hey, these are my wishes. I often say in my practice that that's kind of a gift. When mom makes an advance directive or mom has a conversation with her daughter about what her wishes are, that's really a gift. I've stood by the bedside many, many times where the daughter sits there and they generally pull their hair and there's a lot of crying going on and they say, I have no idea what she'd want. I have no idea. We never talked about this. I have no idea if she would want dialysis. The gift comes in the conversation. The gift comes in the clarity that family members have when they can finally know that this is what mom would want. So that gift is that you are releasing that daughter because you say, look, I have an advance directive that mom wrote. So you don't have to take it on you that if mom doesn't get dialysis, she's going to die. She told me she doesn't want dialysis in this piece of paper. So that's really a gift. That's a gift that a patient gives to their family. I suggest that those of us in here give that gift to our family. And again, we use it as a tool for communication. It is not the be-all and end-all. And another good thing about the advance directives is that it may name a proxy. There are some cons to advance directives. Primarily, the biggest con that I see is that it requires interpretation. I don't know that I have picked up many advance directives and looked at them, excuse me, and said, okay, this patient's very clearly DNR. That's actually the rare case. Usually you pick it up and there's some flowery language in there, and the patients are talking about their life. I get it. Not really stuff that I need to kind of bother the medical record with, but stuff that I'll read to kind of bear witness to this patient's life. And then they'll say things like, if I am declared brain dead, I would like to be removed from a ventilator. I appreciate that. Bioethics in the state of New Jersey tell me that if somebody's brain dead, they are dead. I'm not looking to debate that today, but so we really don't need that in an advance directive. I guess if you put it in, it may be helpful if the family were to argue that. But there are a lot of other interpretations, okay? So interpretations such that if I am in a terminal condition, I would want to have XYZ and would not want to have ABC. So how do you define a terminal condition? Can any thoughts? Anybody give any thoughts as to how you would define a terminal condition? Who thinks, let's see by show of hands, and we should have used the audience response system. By show of hands, who thinks that a terminal condition is one in which you will die within 6 months? Who thinks a terminal condition would be defined by one in which you will die in 12 months? There's really not clarity on that point. And if we think about prognosis, I'm a hospice and palliative care doc. We're only right on prognosis 18% of the time, and I do that for a living. Could you imagine doing something for a living where you only have to be right 18%? I should predict the weather. So we're often wrong, okay? So if we look at it that way, saying that somebody has a terminal condition, I have 80% chance of being wrong and not knowing how the patient defined what a terminal condition is. Is it 6 months? Is it 12 months? Is it 2 years? Because it depends on who you read. Typically in the bioethical world, we say terminal condition means 6 months. But again, it's hard to say. So it requires interpretation. And it may be difficult to generalize, okay? Patients may say that, if I can't communicate for myself anymore, I would not want to have heroic measures. What in the world is a heroic measure? Like, am I going to put a cape on? I have no idea what it is that means when patients write, I don't want heroic measures. I'm going to assume that it means that they don't want CPR and intubation, but your heroic measures are going to mean something very different than your heroic measures. So the language can be fuzzy and difficult to generalize. Another con is that these things can't be followed without a physician's order. So generally, these things are written up by an attorney, or the patient gets it online, or the patients get it from the hospital, and it's a blank document, and they're laying there in their bed, and they say, you know what, I don't have an advance directive, but this guy, Mark Angelo, said that we should have one, so I'm going to do one because I want to make a gift for my family. Okay, and no one guided them through what this is. And then they go ahead and start to click off things that don't make sense, okay? Like, I want to be full code, but I don't want to be intubated. How can you be full code and not be intubated, right? ACLS, airway, breathing, circulation, right? Breathing, airway, first two. Can't do that without a tube, generally. So these things cannot be followed unless I put in an order for them to say that now the patient is DNR, or now the patient is proceeding with dialysis. It does not come with its own set of orders. And only about 15 to 20% of people have advance directives. Can I see a show of hands of how many people in this room have an advance directive? I think I'm preaching to the choir here a little bit, and I think that I just got probably about, you can preach to the choir after this. Behave yourself. So it looks like about 50% in here, but we're the believers and there's 50%, okay? So let's talk about what is a healthcare proxy, okay? It is your surrogate decision maker. In the great state of New Jersey, we have a de facto decision maker chain of command, okay? De facto, okay, which means kind of in practice, okay? So if a patient does not have an advance directive and you're standing at the bedside, or their advance directive does not name a power of attorney, you're standing at the bedside, patient loses capacity. Who do you go to? So spouse or domestic partner is number one. Well, actually, patient is number one, pardon me. Number two, then, would be spouse or domestic partner. That is the old legal definition of domestic partner. I don't know if that's going to end up going away, but as of right now, the way that the legislation is written, you go through to a spouse or a domestic partner. If that doesn't work, they're not alive or will not participate or not available, you go to an adult child. If they don't have a child over 18, you go to their parent. If not, you go to their sibling. If not, we kind of go into this no man's land. And no man's land is defined as a closest living relative who can demonstrate knowledge of the patient's wishes or functions as nuclear family. I work in Camden. Many of my patients don't have advance directives. I think 15% would be a hardy estimate. I would probably estimate it more at 5 or less. And many of my patients aren't married. And they may have lived with someone for 15 years. New Jersey does not recognize common law marriage, nor would it matter because there's nothing here that says you're common law wife or husband. So who makes decisions for that person? This is a very common dilemma that I'm faced with, and one that you may be faced with as well, as you know, families kind of evolve into many different iterations. So you may find that there may be somebody who's living with somebody for 17 years, but they have an adult child who they don't really speak to anymore. So who do we go to? That's the question, and you know, the legislation doesn't help us all that much, to be very frank with you. Basically, you can't take what the 17-year partner has to say other than it is a suggestion, and you can't kind of override the adult child because this house partner has said that they haven't spoken in years. You have an obligation to at least try to reach out to that child. Now, here's a question. I have often heard it said that a spouse comes in and says, you know what, I can't make these decisions. I'm going to assign our neighbor. She's a nurse. She's really smart. She knows what she's talking about. Who thinks that's kosher? It is not. You can take yourself off of this list. You can say, hey, you know what? I abdicate. I will not make decisions for this person. You know, I can't make decisions. It's going to weigh on me too heavily for the rest of my life. So I will not make decisions for this person. So you can abdicate and say, no, I won't do it. You cannot assign someone else. You don't have a right when you sit in this de facto list. You don't have the right to assign someone else. Like, you can't say, well, let's skip this person, I don't like them, and this person's half demented, and this sibling is a total jerk, so let's go with their cousin. You can't do that, okay? We, the practitioners, have to really stick to this as much as we can. Okay? So, moving forward in history, we move to this new form of an advance directive called the out-of-hospital DNR. Who has heard of the out-of-hospital DNR? I see a few hands. Not a whole lot of people are familiar with this. This was designed in 1997. It is a New Jersey product. And it's where a hospital or a physician basically sign this form to say that the patient would not have CPR if fire rescue comes to get them. Where does this become important? In hospice. So you have your hospice patients at home. So we were signing out-of-hospital DNRs for hospice patients at home because if fire rescue gets called and they go to the house, they're obliged to do everything, including full code and intubation, unless they had some order or direction otherwise. Any EMS people in here? So EMS people, you could say, well, I can always call into the hospital. And we can call, we have a direct line to the physicians. And we can we can say, hey, this is a hospice patient. Patient was seen in your hospital. Do we have to code them? How long does it take to get somebody on that line? Right? So not reasonable to think that you're going to call the medical command center and say, I have now spoken to the medical command center, let's stop this code. A good 15 minutes have gone by and enough anoxic time that, nobody's real happy about that. So many facilities don't know about it. Even people who know about it don't follow it. It gets filed in with the 32nd day of a MAR, and nobody knows where it is, and it kind of becomes this unimportant document. So then along comes POLST. POLST was started in the 90s. It was started in Oregon, which I guess they think a lot about end of life in Oregon. I guess there's not a lot to do in Oregon. So they think about end of life, and they smoke a lot of marijuana. And no, anybody from Oregon, I'm sorry, okay? I'm sorry. I'm sorry you're from Oregon. This was not meant to be. How did this happen? So along comes POLST. So started in the 90s, started in Oregon, and it was this new legislation that came out that now this is the practitioner's orders for life-sustaining treatment. So now I, a practitioner, sit down with a patient and we review what your wishes are and we write it down and I sign it and it's an order. And it's a piece of paper that you could say, hey, I have an order for this. So again, POLST, practitioner's orders for life-sustaining treatment. It is voluntary. You do not have to do this if you choose not to. Now, if someone has one, you have to follow it. And we're going to talk about what those punishments are if you don't follow it. But it is a voluntary document. You don't have to do this with your patients, but it is a very good tool, and I hope that you're going to get that feel that it is a good tool by the time we're done talking. It's a green document that we fill it out, I sign it, patient signs it, patient keeps it. I copy it and put it into their record. I usually copy it and put it into our electronic medical record. It clarifies preferences for life-sustaining treatment. It can stand alone or it can work in conjunction with an advance directive. So I often will tell people, if you have $250 and you'd like to give it to an attorney, you can do that and make an advance directive. But if you want, we can do a POLST for free. And I'll only take half the $250. And the POLST is portable, durable, and binding. Portable means that if I see a patient in Camden and we fill out a POLST today and they come here tomorrow and the POLST is signed by me in Camden, that document is in effect here. I'm not on your medical staff. However, it is still a binding document. You are still bound to follow that. Durable means that it is in effect until it is rescinded. And binding means that you have to follow it. We're going to talk about that a little bit more in a moment. So why do we need this? What does this do for us? There we go. Okay. So one of the things that we found about advance directives are that patients' wishes are not being honored because an advance directive, it's too nebulous. Nobody knows exactly what to do with it. You have to sit down and read it. It's 7 pages. I start to gloss over after about the 3rd page or so. So, people are not following advance directives. So we found that wishes are not being honored. Families need this because they need to know. Remember I said about that gift? Families need to know. Families need to know what it is that their loved one wants. EMS and ED personnel, prior advance directives need to be interpreted by the physician. How reliable is that? Anybody ever work in an ER and somebody comes in and they're coding? Okay, generally their advance directive is not clipped to the front of their chest. Would be nice. However, you often don't know. So if someone has a pulse and it comes from the nursing home almost taped to their chest, you'll know what to do. These are documents. I always say that the pulse document, you treat it like the patient's shoes. You wouldn't throw them away, I hope. You would give them back to the patient. They are the patient's property. So often, advanced directives are not operational in emergency settings. Pulse are. Healthcare practitioners need them because advanced directives are up for interpretation, as we talked about, terminal conditions and irreversible conditions, etc. And the law needs it too, because now we have actionable orders. Because if I signed that someone in Camden is DNR and didn't do a pulse, they come here, guess what you got to do? You have to have another goals of care discussion. Dr. Friedman's going to be talking to you a little bit later today about goals of care discussions, but you'd have to have another one. Wouldn't it be nice if the patient, for the patient's sake, that they really only have to go through that once? Once we have it, it becomes the law. It has to be followed. There was a great study that came out very recently in JAGS, the Journal of the American Geriatric Society, and found 96% success in long-term care with pulsed. They defined success as patients' wishes being written down and being followed. I don't have a similar study to look at advanced directives in long-term care settings, but I can promise you it is significantly less than 96%. They also found that patients with pulse had their wishes followed, and EMS noted that pulse changes care in about 45% of the cases. So this is huge. This is a document. This is working. You need to use it, you need to know it, and you need to follow it. This is something that we have found, maybe not the finest solution in the world, but we have found some key that you can use. It is worthwhile, I promise you. Let's take a look at the form, let's see how this works, and let's see how we're going to use it, okay? This is what the form looks like, okay? It starts out with, Section A, which is goals of care. Dr. Freeman and I were actually on the steering committee for developing this form, and we toiled over things for a while. We started with goals of care. We didn't start with code status, because we want this to be the way that a goals of care communication flows, okay? When you go and you're talking to a patient and their family, about what they would want, you don't start off with, if your heart stops, you want us to restart it? You start off with, so what are your goals? Now that we found that, you have a really severely diminished ejection fraction, and you're at pretty high risk for sudden cardiac death, what are your goals? What would you like? When you fill this out, do not fill it out with a lot of flowery language and things like that. Be specific. Comfort, chemotherapy where appropriate or feasible. Pardon me. Should shut that off. Or whatever else they may want, but be very specific about filling out goals of care so that when someone reads this, they will know. And be short. Section B is medical interventions, and there's a couple points I'm going to make. This does not project incredibly well, but I'm going to point it out to you. Okay, so medical interventions. You can say, hey, I want full treatment. Okay, I have an early stage lung cancer, and I think it's worthwhile to seek every treatment possible because, we're aiming for a cure. We're going to get a resection. I think that's the direction that I really want to take this. I'm a relatively young lady, so, I want to go for full treatment, okay? So that's all your standard. There's no question, pretty much when everybody comes in the door, they're considered full treatment, right? So you would, no surprises as to what that is. Then you can set some limitations if you would like. You can set limitations like I would want antibiotics, or I would want IV fluids, or I would not. Would you want to be transferred to the hospital for medical interventions? Would you want to be transferred to the hospital only if comfort needs were there? So, i.e., you fell and fractured your arm, yes, take me to the hospital and get it set, because that's a comfort-based thing. The other category is symptom treatment only. So this is for patients who say, thank you, but no thank you, I never want to go to the hospital again. And really all that these patients are interested in is aggressive comfort treatment. Okay, I always try to be careful about the word aggressive because it's just like heroic. What does it mean? Okay, when we're doing comfort measures, we are using aggressive comfort techniques. Okay, I got people on morphine drips. I have people on ketamine. I have people, doing all kind of crazy things to try to get them comfortable. I don't think I would define that as a non-aggressive approach. It's aggressive in comfort. So be careful about saying aggressive versus non-aggressive treatment, because this is aggressive treatment. But what we're talking about here is symptom-based treatment, not disease-modifying treatment. Section C is artificially administered fluids and nutrition. You couldn't be much clearer on this. No, or a defined trial, or yes, I want long-term artificial nutrition. That's pretty clear. And then we come down to this CPR section, okay? We put the caduceus in here so that everyone will know that, this is where kind of our EMS's eyes have to be drawn to. So the caduceus is here if they want to just kind of look right at this, because, we need to just scan this document immediately. And it is all one page. We are still on the one page here. So again, we're trying to be simple. We're trying to simplify this process. So if the patient has no pulse, okay, which, oh, by the way, is a dead patient. So the patient has no pulse and or is not breathing. Attempt resuscitation and CPR, or do not attempt resuscitation, the NAR, allow natural death. So again, simplify. We don't have a third selection on here that says, well, I would want to be shocked twice, and I don't want any chest compressions because I heard that breaks your sternum, and you could do one round of drugs. No, that is not an option. So when patients say to you that I would like to say I want one shock, one epi, would never want to be put on amiodarone, can't do it. Let's go back to the drawing board and talk about your code status again, because we can't accept it that way. So these are your choices. Okay. Airway management. Person is in respiratory distress with a pulse. This is a live person. Do we intubate or do we not intubate? Okay, so you see the difference? If we go back here, I'm having a little sticky problem here. So we attempt resuscitation with a dead person. Or without a pulse, or I'm sorry, with a pulse, we intubate or do not intubate. Okay, we're getting the difference there. And if you have specific questions, I'm going to leave a couple minutes for time for discussion thereafter. Section E, this is what it looks like. These are the words. If I lose my decision-making capacity, I authorize my surrogate decision-maker noted below to modify or revoke these New Jersey Post orders in consultation with my treating physician or APN. Holy moly. Because what does that just do? You can cancel the whole thing. Ever take care of a patient and they're telling you their wishes and the daughter's there like this? And you know that daughter has no chance of going with mom's wishes. If mom clicks yes to this and mom loses her decision-making capacity, the daughter can now say, thank you, Post. Gone, and I'm making the rules from now on. That is a problem. It requires a lot of communication, and it's going to probably require some alcohol on your part. The good reason that that's in there is that there are things that happen that are unpredictable. Let's go back to the young person who has an early stage lung cancer and wants full aggressive treatment. They want full aggressive treatment, full code, full everything, full intubation. I would like to have, chemotherapy is my goal as long as feasible, et cetera. And now all of a sudden, that person has a stroke. And their husband says, you know what, we have had many a conversation, and she has said that if she were going to be bedbound with no hope of getting out of that bed, she would not want to continue in that vein. So therefore, we're going to rescind the Post and we're going to make her DNR. So in that situation, it makes sense. In the first situation, it's disastrous. Patients have to know their surrogate. Okay, I have had an instance where a patient blocked her husband from being her surrogate because she was quite sure he was going to overrule her wishes. And they came back in, and he was irate at me for allowing her to do this or encouraging her to do this. And I think my response to him was, I think the fact that you're irate, that you're being blocked, is the exact reason that she's blocking you. Because she's worried, if you really didn't, if you were really planning on following her wishes, it wouldn't be that much of an issue. So know your surrogate decision maker. So what does the Post do? It represents a prior communication. So it says, you have had a conversation with me, and we have now memorialized it. It doesn't really require interpretation. We know what you want. Portable, durable, binding, okay? Who is encouraged to use it? By the legislation, these are the people that are encouraged to use it. Anyone who chooses to be DNR or allow natural death. If you choose to limit therapies for some reason. If you are frail and elderly. If you're living in a long-term care facility, or expectations of life are less than 5 years. Expectations of life less than 5 years? How in the world do you know that? That's crystal ballism right there. So when someone comes in with their Post, it was signed by Dr. Angelo in Camden. It's the law. It's an order. I suggest that you review it and you say, okay, Mary Smith, you sat with Dr. Angelo yesterday, you had a conversation, and it looks like these were the things that you picked out for your wishes. Want to just let you know we will carry through with your wishes. Doesn't mean that you have to have the conversation again, but you should recognize as a good practitioner that it's good to have that conversation. It's good to just say, recognize what you've said in the past, and we'll make sure that we follow your wishes. A Post should be reviewed or renewed when someone's health status changes. So when you go from that real early stage lung cancer to advanced metastatic, something in the brain, things like that. So now, your treatment options change, and your pulse should be at least reviewed, if not renewed. And when transferred to another facility, like I said, it should at least be reviewed. So, what happens if you choose to ignore a pulse? First of all, what happens if you choose to ignore an advance directive? Nothing. Nothing. You could probably argue at any given point that it was not applicable to your situation. Now, could somebody come after you for malpractice and say, you know what, this was a document that my mom wrote, and I think it was pretty clear, and we'd like to argue the point that that should have been followed. So I guess potentially. I'm not aware of a whole lot of lawsuits regarding that, but it could be. If you choose to ignore a pulse, there are fines. There are fines to your institution as high as $25,000, and there's liability that you carry, and it's not medical liability. It's not malpractice liability. If you say, I've read your pulse, it says your DNR, and we're not following it, that is a violation of the law. If you say your pulse says you're full code, but I decided that you should not be full code, and I personally am going to take it on my shoulders to override this, that is a crime in New Jersey. That is a level 1 crime. So that there could, you could be arrested, and you can have to pay fines, and that's not something that your malpractice insurance will cover. That's something that your pocketbook will cover. So if your patient has a pulse, you need to know about it. I guess you can claim ignorance and say, hey, didn't know that the pulse existed. But as medical systems, it's important that we have these pulses right out there. I was part of the committee that put pulse in the forefront at Cooper, and we put a banner up top to say, patient has a pulse, and when you log in, and there's something that says patient has a pulse, and the code status is pulsed/full code or pulse/DNAR. So it's important that as institutions we make this information known. But it's important as practitioners that you review that information and you heed it. It's important to be a good practitioner to do that, and it's important that you do it from the standpoint of the law. So just to kind of very briefly review, this is the pulse, this is the advance directive, this is the out-of-hospital DNR. Please be aware, the pulse is supposed to eliminate the out-of-hospital DNR. So if those of you don't know about this, don't even give me any neurons, because really you're wasting your brain energy. Focus here, because this is going away. So a pulse, is it a medical order? Yes. Is an advance directive a medical order? No. Out of hospital it is for EMS only. Pulse does not require the loss of decision-making capacity. So I can make myself DNR, and you don't have to wait for me to lose my decision-making capacity to make that come into effect. With an advance directive, you do. Out-of-hospital DNR, no. Pulse is portable. Advance directive is only portable if it's accompanied by an order. And here's by EMS only, of course. May be completed by a proxy. So my wife can fill out a pulsed form for me if I lose my decision-making capacity on the way home today. There is no other advance directive like that out there. So be aware. You can still fill out a pulse for someone if you fall in that de facto decision-making chain of command, as we talked about. So obviously we talk about the patient, spouse, parent, sibling, adult child. So you can fill out a pulse for a proxy. So now all of a sudden we can have advance directives for children, because we didn't have them for children before, because you couldn't make an advance directive, because you can't consent. The pulse requires a signature by the practitioner and the patient. Advance directive is only signed by the patient. and the out-of-hospital DNR is only signed by the practitioner. So we brought you both together. The POLST may be modified by a proxy, and we talked about that. The advance directive is not modifiable by a proxy, although if I open the floor to this, I'm sure that many of you in here can give me stories about when a family member has refused to follow someone's advance directive. And an out-of-hospital DNR cannot be modified by a proxy. Yes, it designates an agent. Yes, it designates an agent. No, it does not. And none of these are expiring. So keep in mind, if you have a document from 1991, unless you can prove, well, not the POLST won't be from 91, but if you have an advance directive from 91, unless you can prove that there's another one or there has been some conversation to the contrary, it's still in effect. So everything you need to know on one slide. Advance directives are present for 25 years, though they are not highly utilized. They convey patient preferences in the event of incapacity, and they may name a surrogate decision maker. The POLST is new and highly effective tool for advanced care planning that's actionable, and it allows for practitioners to memorialize conversations across settings. I thought this was interesting, and I don't know, I'm just not sure how to get advanced directives out there in the forefront. The other thing I'm not sure of is where this tattoo is. And from what I'm gathering, it's not somewhere you'd see when you were going to do CPR. I'm thinking it's some hind region. It is signed. It is a reproduction of a signature. I asked our senior general counsel at Cooper what he thought about this, and I'd love to hear what the attorneys here think about it. And he's a very straight-laced guy. I love him, but I don't think I want to go to his house for a party. He said this is not enforceable. I'm not sure if this thing is enforceable or not, to be very frank with you. I think that that's something that we may need to have a judge make a decision on, and that's not my area. Okay, that's all I got. I think, am I over? Oh, we have time for questions. And we do have a rolling microphone that we will bring to you for questions. Comments, testimonials.
Hi.
Hi.
My name is Dr. Savio. I'm an internist, and I generally have a question about, I still have the confusion of explaining to patients about the POLST again and the advance directive, but you made it a little more clear. Because this is a legislation or an issue that has just been enacted in the last year, would this eventually, I guess my question is, it says long-term care and frail elderly. What about the young patients who we have a discussion about advance directives? We still use the advance directives, or are we moving slowly to
That's a good point. Right now, the way the legislation is written, it was for those 5 categories that I mentioned. It's not intended for patients who are young and well. For those patients, it's still suggested that you use an advance directive form. I could tell you this. In my experience, patients' wishes change. And when you talk to someone who's 30 years old, they may say, if I can't play basketball, I don't want to be full code. And then when you're 51, it's a different case. You say, well, if I can't walk and be independent, I want to be no code. And then you're in your 70s and you say, well, if I can't have a conversation, I want to be no code. So wishes change as time goes by. So it's something that should be periodically readdressed anyway. So what I would generally suggest in those instances, if they don't meet the typical criteria for advance directive, like having some critical illness, a life expectancy of 5 years or less, living in a long-term care facility, and the others, I would probably not use the POLST.
Well, let me make this comment because a lot of, I guess, requirements that we have to do in EMR suggest that we need to talk to patients, whether they're young or old, about advance directives.
Right.
And I put it in a fashion, well, if you just walk out this door and get into a motor vehicle accident and you're brain dead, who's going to make the decisions for you? Would you want to be intubated? They kind of like, oh, okay, that makes a whole lot of sense.
Right.
The other thing is that the pulse is very simplistic. It's 1 page versus 20 pages. So if you have a young person, you know, even though their brain capacity is much better than an older person, but that can be argued in some cases.
Sure.
The 1 page works a lot better than 20 pages of stuff.
Right. Flowery language that may not be helpful.
Because it's very specific and very detailed and it's amendable. So that's just why I tend to, you know, when I talk to people about the advanced directives and you hand it to them, you don't hear about it again.
Right.
If you give them 1 page or 2 pages,
They may be more likely to
more likely to
consider it.
oh, okay, and then they put it in.
So, you know, I could tell you that it is my hope that we will be utilizing POLST for patients outside of those categories. For right now, where the legislation is, the legislation has chosen those more vulnerable for use. But that's a great point. And I appreciate the fact that you're having advance directive conversations with your patients, because patients want it. There's another question? Gotcha.
My name is Elias.
Hi.
Physician advisor, captain of palliative care team at our hospital. Now, you said that when a patient has a pulse, the physician should sit and discuss it with him. I would rather, honestly, the physician tell him, we have your pulse, we know what about it. End of conversation. Because physicians have a tendency to give their opinions, their feelings, that are influenced by many factors, culture, everything else in between. And we have a problem, especially when there is more than one physician on the case. I think in the history and maybe somewhere prominent on the chart, there should be big letters, this patient has a pulse. And many cases where nurse will tell you about that. One physician walks in and says, you have no hope, you won't live another 6 months. Another physician comes in and says, oh, you're fine, you're going to see your grandchildren, or whatever. And that is a problem. I think physicians should get together, more than one physician on the case, or appoint the primary care physician, the attending physician, to make the decision on prognosis.
Right, with
It's not fair to
the patient.
They tell us this one guy tells me, I'm done, you know, chances of surviving this illness are very small. The other guy says, oh, no, we make you better.
And we've all had that scenario where where I do palliative care, we do a lot of critical care consults, and we've all had that scenario where, you know, we have the conversation with the patient, and then the next day the kidney doctor goes in and says, thank God your sodium is better. And now we're like, holy Lord. You know, we just had a whole conversation about this, and, you know, now we're reopening these things. But in answer to your question or your comment, I think it's important that we just kind of recognize, we say, hey, you know, we do have your POLST. We see that this was written. The only reason that it's important to have any review is because there's a chance that's not the last document. There's a chance that what you're holding is not the latest thoughts of the patient. If it's yesterday's date, I'd feel pretty comfortable. If it's a year ago, not so sure. So I think, you know, it's just at least worthwhile to say, got your document, this is what it says, and we will make sure that we follow these directions. I would not reinitiate the conversation, though. it's painful for patients, it's painful for practitioners, and it's unnecessary. Good, thanks for your point. We have a question up here. Who will get to him first? It was a race.
Bill William, geriatrics.
Hi, Bill.
I can see this working in long-term care facilities, but what about the scenario a patient of mine comes in with a pulse that gets put in their chart? 9 months later, I get a call from the emergency room. Your patient's in here, they're short of breath. What do you want us to do with them? Or, we need to admit them. How do you keep track of your outpatients that have pulse?
If now in that kind of scenario, you may not have time to log in to your record to check and see if a patient has a pulse. The patient may have a pulse on record with the hospital. In New Jersey, there is no central registry for pulses. I wish there was. There is not. There was no funding for it. It was discussed. We're hopeful at some point in the future that may be the case, that we could put it into a central registry, and then the ER doc can just go and just type in, Bob Smith, and then Bob's advance directive comes up. We were able to move towards central registries for things like New Jersey RX reports. So, why would we not be able to do this? I think it has to be a priority, and the funding has to be there. So that's an excellent, excellent point that, how will we know if the patient has a pulse if they can't tell us? It's a green form. It's supposed to be on the front of their chart. It's supposed to be, in banner form on the electronic medical record so that it's kind of highlighted, no matter what happens in subsequent encounters. But if you filled it out in the office and it's locked tight and, all your records are HIPAA compliant and you don't use an EMR and it's Saturday night at 2 a.m, no one will know the patient has a pulse. It is expected that you will then produce it when you see the patient, and then you'll try to kind of jibe up whatever happened with the patient with what their wishes are now.
I know my patients have EMR or have advanced directives, and when they show up in the emergency room, the family member says, oh yes, it's home on the dresser. I'm sure the green form is going to be home on the dresser too, and then it's a matter of asking them, well, what did it say, because it's not there with them.
Right.
Just as a corollary, later on, I'd like to ask the same question to the attorneys.
Right. Okay. We have another question.
Hi, my name is Megan Cunningham. I'm a social
Hi.
worker at palliative care. I often feel, because I'm not a nurse or a physician or a nurse practitioner, that I'm much more on the level of the patient when it comes to getting choices explained and trying to decipher those choices and what does that mean. In my experience, many times patients and family, when you talk about CPR and ventilation, they think of the movies. They think that you get CPR and you come up out of breath, almost like the Heimlich, and everything's better. And that the worst case scenarios are out of bed. They don't see the correlation. They don't see the treatment, how it would usually go. How would you suggest having that conversation, and again, keeping it in, not to use the word simple terms, but in terms that they can understand and they can envision for their own healthcare issues and end-stage COPD, whatever it might be, and so that they can feel comfortable that they're making the right decision. Because my experience, again, is that they default to, well, then just do everything, because I feel too nervous making this decision.
Right.
I'm going to make a decision that's going to end my life. Just do everything.
Right. So usually I would suggest that you have someone who is skilled in these conversations having the conversations. We don't let our interns do these conversations because they've not done them before and they're not skilled at it generally. There are some attending physicians that I think we should not allow to do them either, but I don't have the authority to take that ability away from them. Really what you're getting at is it's called decision-making support tools. There are a number of decision-making support tools out there. So I'm actually writing one yesterday, believe it or not. Interesting that you mentioned this. And it's about CPR. and it's, what is CPR? What happens during CPR? What do you expect? So there's so that this is something that you can give to patients. There will be two levels. There will be patients who are on a very basic 7th grade reading level, and there will be patients who are on a higher reading level and will want some more data. So there will be two sets, and it's going to be talk about things like CPR, talk about things like feeding tubes, stuff like that. There are some products out there already, commercial products out there that are available for decision-making support tools. There's actually a set of videos that I'm trying to get my home hospital to buy that patients can look at on an iPad. I'm hoping my patients don't steal the iPad. And it's basically, they're very simple language, easy stuff to say, this is what happens during a CPR, and they're not gory. I am not one to try to scare someone into a code status, but I do think that if you're making a decision, it should be, with your eyes open. So if you're making a decision to be full code, because I want to be able to say goodbye to my family, that's a very unlikely scenario that that's going to happen, because you will have a broken sternum and broken ribs, and you'll be intubated and probably on a fentanyl drip. So it's a very unlikely scenario that that's going to allow you time to say goodbye. Decision-making support tools, give me your business card. I'll share it with you when we're done. Okay. Oh, we got another question?
Hi, my name is Cassie. I'm a registered nurse at Search Telemetry Unit. Just a simple question. Is this portable to other states or only other states?
Great. Great point. Thank you so much for that. Yes, it is transferable to other states. An order here is an order in Pennsylvania who doesn't have a pulse. It's an order in New York who has a MOLST. They call theirs the MOLST. They have to be difficult. And there's other states that utilize it, and it doesn't matter whether they have legislation or not. It is enforceable in other states.
Okay, and then I just have a little more complicated question. The first line of the pulse, when it was kind of like the small writing, it said it was more related to the current health of the patient and the illness that was going on. So when you gave the example of the woman had the early stage cancer and then all of a sudden had a stroke, and the family wanted to maybe change whatever was going on. Now, what if she hadn't listed a healthcare proxy, but that stroke isn't necessarily related to what she was originally filling the pulse out for? Does that kind of get a little sticky?
I get it, and I certainly get where you're going with that when the patient filled this out, it was based on their current healthcare status, and now there's a whole new playing field because now we've had a stroke. We're just trying to work with the information we got. It's unlikely that there would be a second document filled out. Now, that may be an instance where an advanced directive with some more language would be helpful. I would venture to guess that it probably wouldn't be, but it could be. So, we're just trying to take whatever pieces of data we have to kind of say, what is this patient's life philosophy, and how would they define, the proper way to handle their body? So we work with the information we have. I don't have a perfect answer for your question, sorry. There's one more question?
Risk management.
Yes, call risk management. That's always the answer. I think we have one more question, and then we'll call it. Is that okay?
Actually, just have a comment.
Oh, okay.
I just wanted to speak to your point, Dr. Boyan, because I think it's a very important point in terms of how are we getting the pulse from the physician's office into the hospital. We are working towards a system within Meridian's electronic medical record where if a patient has ever been in a Meridian hospital, even in an outpatient setting for an x-ray, and they have a number, what we're working towards is letting your office staff be able to fax the pulse directly into our EMR. It'll then be put in the right place because we do have a spot in the EMR that goes across the lifetime record of the patient. So it's there no matter if they were in Jersey Shore or Bayshore or Ocean. It's there and it stays there for repeated admissions. The other thing that we're working on is what we're calling an e-pulse registry through something called Allspire, which is Meridian is participating in. And so we are making really good progress towards that. And ultimately, once that's up and running, hopefully it will be expanded to the whole state. So there is progress being made. It's just it's a slow process. And the other thing that I wanted to comment on is that we actually are using those videos at Meridian.
And the Angelo Volandes videos?
Exactly.
Yeah,
and
they're great.
outstanding. And right now, our palliative care teams have them. Hospice is going to start using them as well. So
Yeah.
I just wanted to make that comment.
They're great. If you want to Google, his name is Angelo Volandes, Volandes. You can YouTube him, and you can look at these videos. These videos are phenomenal. They're easy language, very plain and simple, straightforward. They're wonderful. Then we had another question.
Hi, my name
Hi.
is Grace Riley. I'm a nurse practitioner.
Hi, Grace.
I'm wondering how your hospital is handling a situation that I encountered for the first time 2 weeks ago. A woman was coming into the cardiac lab to have her pacemaker battery changed, and she had the pulse that said DNR. No CPR, no intubation.
Okay. That is a loaded question, but thank you for asking it. Oh, we are out of time. We don't have an answer to that, and the same would go with, what about people who go for simple surgeries? One of the risks of anesthesia could be asystole. And do we have to say that the patient dies on the table from a hernia repair? So our surgery division would like to say that pulse get held when the patient goes. But the reality is, the way it works, you have to have an order to hold a pulse, because it is a medical order. So when they go to the OR, they need an order to suspend the pulse. The suspension order is discontinued when they come out of the OR. Does that always happen? No. Okay, and you seem lovely. You had one more question. You had your hand up before, and I promised you we would let you. And then that's going to be the last one.
Hello.
Hi.
My name is Ann Hopkins. I'm a social worker.
Hi, Ann.
One of the difficulties with the pulse that I'm encountering, which won't surprise anybody in this room probably, is that physicians have a tremendous, in most cases, not every case, but a tremendous difficulty talking with their patients and getting their minds wrapped around the pulse and these issues. Is there anything going on educationally with physicians to help them feel more comfortable addressing these issues?
Why, yes. There in New Jersey, there is a new regulation from the State Board of Medical Examiners that there are now 2 hours of required CME per cycle in end-of-life care. So the answer to your question is yes, it's on the radar. We have recognized that this is a problem. So now, no matter what you do, whether you do pathology or pediatrics or gynecology, you are now required to have 2 hours of CME credit. And that's a big deal. If we're saying that you need 50 total, and now two of that has to be end of life, that's a big deal. It's not taken lightly. And we're here today to try to help to spread that message. And I hope that we were able to kind of get that across to the people here in the audience. But so that's a very good point. So yes, we are. It's on the radar, and we're doing what we can. Okay, we're going to wrap up. Thank you.